The new chief deserves all the support that any of us can give her now, because they're testing her. In a different forum, I concluded years ago, I used to go back to Washington. I would try not to stay very long. But I noticed when you go there first inside the Beltway, they kind of whack you and accuse you of something. You just make it up, it doesn't matter. And they whack you with something, see if you can take a shot. Then you come back the second time, they're a little bit more respectful. If you come back the third time, then you're one of them. See, that's the way it works in politics. So we have a new chief. Is that irrelevant to the question that we stand here with the governor who says more cuts? See, there are the parts of it. So anyway, we had the hearings, and they were helpful. And there was one in Sacramento aimed at showing that cuts in funding for the courts and legal services threatened efficient, effective use of taxpayer dollars. There were witnesses there that would bring tears to a stone. The one I remember at the moment is a judge who has the family court in Sacramento, and he explained what he has to do. There's a judge in Santa Clara who on some days has walked into her court, gotten up in front, looked at a totally packed courtroom. There's not a lawyer in that room. There's not a single lawyer in that room. San Francisco, and I was chair of the San Francisco one, aimed at showing that cuts in funding for the civil justice system create barriers for the effective work of business, professionals, and foundations. We had people from Hewlett-Packard. There's a lot of people out there worried about their ability to get things done. Los Angeles aimed at showing that cuts in funding for civil justice system imperil access to basic life necessities, housing, education, social services. Irvine, the hearings there aimed at showing how cuts in funding for the civil justice system threatens efficient and effective use of taxpayer dollars. Our committee is proposing, and I'm supposed to appear before the board of directors of the bar in San Francisco on Wednesday, a rule of court that's very simple called appointed counsel for indigent litigants. Court-appointed counsel. Where a civil litigant is indigent, as defined in subparagraph A, the court may appoint consenting counsel. Consenting counsel. No slavery argument here, okay? There's a slavery argument. I mean, people say, you can't make me do it, right? Okay, so go home, all right? Go away. May appoint consenting counsel where the assistance of counsel is needed to protect the litigant's rights to basic human needs or fundamental rights, including sustenance, shelter, medical care, safety, child custody, and placement. Why the rule? Because anecdotal examination of the situation indicates some judges are already doing this. There are statutes, of course, that say they can be appointed counsel. That's that whole category. Then there are a whole host of cases where there is no statute, therefore no counsel, so the thinking goes. But some judges say, this has to work. So let's get a list of lawyers who volunteer. There are all kinds of arguments that are very interesting, and our little committee is blowing by that. And also, it will endorse the idea that was present in my lifetime before Gideon. This is the way it was done, back to Mr. Beck. There was a whole generation of lawyers, because I do criminal cases, and I would meet them. They'd say, you know, I had a criminal case, Judge so-and-so appointed me and so forth. I only had the one. And then they talk about it at some length, because maybe the rest of their practice has not been so exciting. I don't know. But it was an ethos in a generation of lawyers that had an idea that it was partly their responsibility. We have more ideas in our little committee. For example, we've had many standards. I think the first one came from San Francisco. Lawyers should spend 5% of their time on pro bono and so on. Our idea is a little bit different, although related, and that is that every lawyer has to do some pro bono. Every lawyer. Now, firms will say, well, you look at the total and we're doing 5%, and that's true. But every lawyer has to do pro bono. It doesn't cost any money. This rule doesn't cost any money. The hearings didn't need money from the legislature. And so these are things that are there. Well, the budget came down yesterday. It says in here that none of these cuts are hurting the court system at all. I thought that was a statement that one can say, and there it is, and you can hear it on the radio. But from everything I've said, you can imagine that I wonder about that. They want to use the reserves the courts have. They're stopping the construction program, which involves some safety issues in court. And the administration proposes to establish a working group to conduct the evaluation. The working group will conduct a statewide analysis of workload metrics, staffing standards, and other relevant data necessary to support a more uniform and efficient administrative system of the judiciary. And that brings me to my call to my state senator last week. Of course, I didn't talk to her. We know that. But I invited the staff person to give me a call if she would like to, and so far she hasn't called. And I said a modified version of what I said here today. I was calm, I was quiet, but I was insistent. And the first line of defense was that the senator's doing everything she could do. That didn't work. The second line of defense was there's been a computer gaffe in the state structure, and that didn't really work because I teach a class on persuasion at Bolt Hall, and what I said to the clerk, I said, look, you make that argument, and in political circles I'm sure that's interesting, but to the man who's a roofer in Oakland who can't get access to the courts, that argument doesn't work at all. And so I'm not persuaded by that. When we had the hearings in Sacramento, a very senior staff person came up to me and tried to direct me to people in the other political party, as though, you know, somehow just go away, just move on.com. So the final, there are other things that will solve some of these problems, but the one I want to raise today, and I was going to raise it before these recent cuts because there are discussions about it as we speak, and that is that we have a constitutional showdown here. I think that's true. Sometimes I get up in front of an audience and I utter excited utterances. People of Irish extraction, I can say this, we do that, you know? We're trying to relive, you know, Easter week in Dublin, you know, or something. Who knows what genes we carry with us, right? But this will not pass. This is too much, okay? And what do we base it on? Article 3, Section 3 of the state constitution provides 3 independent branches of government, and the legislature has an obligation to fund the courts. They can have rules on jurisdiction and they can do lots of things, but they cannot deprive the courts of those monies that they need to function. The courts are not the Department of Agriculture. They are not even the schools, as compelling as that is. The courts have to function in California. And those who raise their hand against the courts will encounter resistance. It may be 5 people, it may be 50. In front of City Hall 3 weeks ago, it was 500. It was 500 that represented every aspect of the legal community. Justice Douglas Miller, who is the chair of the Executive and Planning Committee of the AOC, which helps the courts to function and gives them direction, made an impassioned plea that the legislature not tell the courts how to run the courts. There have been reliable reports when asked why they don't put the budgetary matters for the courts on a more stable basis. The answer was, this is not unusual up there. Well, we might not like an opinion that you write, and this gives us a little control over you. I practiced law a long time. I have seen what control by the legislature has done to the state bar. I have seen the state bar's budget held up a number of times, and I've seen the state bar, and a good friend of mine, and probably some of you, is running the state bar at the moment, has been reduced and reduced and reduced, so that discipline is now the major thing, and this year there were efforts to take that over and take that away from the lawyers. So the fundamental difference between the legislature and the judiciary, except for judicial elections, is one of them takes money and the other doesn't. And that's fundamental. So at the point where the legislature is going to dictate what's going to happen in the courts, we're in a lot of trouble. So there's a case. I brought a case, and then we'll take some questions. And the question should be, like, there any good news, Brosnahan? I mean, the Giants won 3 in a row. What? All right. This is the case of LaFrancois versus Gold, California Supreme Court. The sum total of the matter is that the legislature may put reasonable restrictions upon constitutional functions of the courts, provided they do not defeat or materially impair the exercise of those functions. There are no civil courts, I am told, in Kern County. I do not know what that means, for there are civil problems in Kern County and San Joaquin and other places throughout the state. So there you are, and I think that the lawyers have been organizing, working, and the focal point has been to convince the governor and the legislature the courts need to be funded. And I think as of today, I would say, maybe it'll change tomorrow, that those efforts, as gallant as they have been unsuccessful. And so something else, and you can think all afternoon if you have nothing to do about what a case would be like where the courts command that the money be paid. Be a bit of a mess, I should say. But what else is there for the people in Kern County and San Joaquin, these places, all of that. Okay, so now we have questions. Anybody here from the legislature? Yes.
Are you concerned about the closure of the San Francisco County Law Libraries?
Yes. And you can't, there are others that spend more time on all this than I do, but I've been working on it, and I'm on a committee, and we hear reports and all of that. There's a whole pro bono aspect where underrepresented people go to libraries, and there's been a wonderful reaction in libraries to provide them with what they need. And so the closing of a law library, the reduction of services for people, the reduction of self-help, although I do worry that that's becoming the standard, that you just talk to somebody. There's actually, I should have mentioned this, there are people who study statistically whether lawyers do any good. Right? I was on a panel with one. I almost lost it. I mean, it's like, I want to commission a study to see if people like that are doing any good, all right? Because I don't think they are. And so anyway, yeah, I'd be very concerned about the loss of not only just libraries, but the ability of the unrepresented to at least research what they need to research. Where are they going to go? Yes.
How can you keep up with your activities of your cell, or can you even name it?
How can we what?
Keep up with the activities of your cell.
Oh, my cell?
Yes.
Oh.
You can name that.
Can you do this? We put you on the mailing list. It's a great group. It's a small group. It's about 10 people, and we have some bar officers who come to the meetings, and we have some legal services people, and we have very experienced people. The head of the voluntary legal services is there. So it's not just ideas, but it's based on practical necessities. And we tried to think about things that wouldn't cost money that could be done immediately. The hearings were one, the rule is another, and we're working on presenting that rule to the AOC. They have procedures, they need to study it, and they should. But I think I think it'll pass. So we'll put you, if you send me an email, we'll put you on the mailing list, and happy to do it.
And there certainly is precedent for appointing counsel, particularly in capital, murder cases.
Absolutely. Some of it is statutory, but there are judges out there that are doing it. There's all kinds of proper things to worry about. For example, I've heard judges say, well, there could be favoritism. In other words, but in family court, I've done divorce cases. The last one I did was the last one I think I'm going to do 2 years ago, with children and stuff. There's other lawyers a lot better at that than me. But, I don't know that you're doing a favor for anybody if you give them, a family case. But there are those considerations. It has to be thought through. And then there's all the educational part. See, what's happened, the lawyers have gotten much more sophisticated. And we've gotten much more specialized. And so it's not so easy, really, for a lawyer. I know really good lawyers that would like to have, but I don't know anything about family law, and that may be true. But a custody hearing that lasts for 3 hours is about the kid. They know about that. And wouldn't it be better for them to do it than the person by themselves who has no idea about what? No idea how to get a witness. No idea what's admissible and what isn't, even if it's loosely defined. No idea what the law is. It's like, let's do brain surgery on yourself. Here's self-help. This is an artery. This is a thrombosis. Now be very careful when you cut, because that's, Okay. Yes, in the back.
Don't you think this is a result of the Grover Norquist shrinking government so they could drown it in the bathtub school, and this is what we've got, and there are people who really don't care, and I think that it's a bigger problem than just having lawyers do pro bono time. I mean,
it's much bigger than if everybody did 5% pro bono in the state, and there are lawyers that can help more than maybe they're doing at the moment, I think, anecdotally. But I think that, yes, and I think we're in that period, but I'll tell you, we're all friends here. What I really love is when society changes. There's a great book by Albert Camus, who was a literary writer and philosopher, called The Rebels. All right? A little bit incoherent, but you've seen recently some ideas. There's moments in human activity where people say, this is no good. I can't do this. This is no good. And it doesn't lead to violence particularly, but it might lead to people standing up and saying something. So that brings me to my secret point of the day. How many of you have ever called your elected representative on the state level? How many? Okay. How many of you would be willing to call your state senator and say, these cuts are, and you choose your own words, but they're not acceptable, and you need to do something about it. Let's have all the hands go up. All the hands. All the hands. All the hands. Do it. Okay? So you'll be frustrated. So that you'll be talking to some clerk. And, who knows? But that's what's going on. And there are days listed where you can actually, I think I'm going to go up there in about 2 weeks, go to Sacramento and talk to the people. It's called democracy. Yes.
That is a great lead into my question, which is, has your cell discussed strategies for building a constituency in Sacramento, both to support the Chief Justice and also to provide pushback on the budget cuts?
A lot. We've discussed it a lot. The idea that seems to be corporeal at the moment is creation, and this is out of our league, but creation of a video that would go viral. It will be in, I've talked to some videographers. It would be on the blog. See, I know what the blog is. I know how the blog works. Here's the way it works. I call in my assistant and I say, we need to go on the blog. It's not a problem. Okay. And this viral, and this is something that lawyers know about. This viral will be interviews of people in California who had the window closed in the clerk's office when they were trying to pay their fine or whatever it was they had to do. This will be the mother or father who tried to go to court, tried to have custody of their children and so forth. Through editing and all of that, we try to get that out there and get that going. So we have discussed that. I've talked to one of the nonprofits about the possibility of doing it. Because I think in terms of persuasion, you can talk forever about 6 out of 10 this and 8 out of 10 that, and isn't it sad, and let's go back to our work or whatever we're going to do. But if you start showing the results of the closure of the court, I would like, time permitting, I don't have a lot of time right now, but I'd like to go down to Kern County and San Joaquin and just talk to the judges down there and see what's going on. I keep saying, and I'm told by the very reliable, they're closing the civil courts. Well, all the civil courts, is that real? But those kinds of interviews out there is what they would understand. Now, the hidden thing that we haven't mentioned here is money. There was a governor in California a few years ago who wouldn't meet with any nonprofits because they don't contribute to his campaign. That was it for me. That was it for me. That's like, what? Repeat that again. You have to confirm it with somebody else. No, it's impossible. It couldn't be, but it was. So, you know, a video we're talking about. Embarrass them.
Interview all the people standing in the self-help line.
Sure, absolutely. Why are you standing here? What's going on? So that's an idea. Yes?
How much do you think the level of attorney's fees, the high cost of legal representation, has to do with the access problem?
A lot.
The difference between pro bono and $200 an hour.
Yeah, a lot. It has a lot to do with it. And the recession has a lot to do with it, frankly. I mean, the truth is the people in Sacramento have serious problems. They don't have enough money and they have all these needs and so forth. But I think that it breaks down. You can start talking about big firm, medium firm, small firm, and it varies so much over, you know, there are thousands and thousands of lawyers. But in fact, there's an instinct within us, which is correct. Going back to I started in 1959, the 60s, the senior partners had all been through the Depression. Their economic imperative was unrelenting. They didn't want to go back to getting $5 a week. So lawyers have moved to the extent they can to perfect their practices and to charge more. And the young ones, up to 2 years ago, expected to have jobs which would start at a little bit more than my wife makes as a Superior Court judge in Oakland. So I think that has something to do with it. I'm not exactly sure where it places, but it has something to do with it. I should mention, by the way, that my wife Carol is a Superior Court judge, and before the police were reduced in Oakland, and you can decide for yourself what this means, and I'm speaking for myself, I'm obviously not speaking for her, but she would handle, on the average, 150 misdemeanor cases a day. It was worth going down to see Judge Brosnahan handle that. They're yelling out numbers, 352, 987, whatever. He didn't do the number 64, he did the 32. whatever. And all this she handled with, I'm terribly biased, grace and, compassion and professionalism and so forth. Since the number of police have been reduced, the average number of misdemeanors in her court is about 80. That would be a difference of 70 people who would have been in her court, would have been found, apprehended, whatever, who have not been. I link it to the reduction in police because I can't figure out anything else. Doesn't mean I'm right. But you see the implications of what's happening. You see that. And that's a pretty good example of it. We have time for one more question. Yes.
Yes, kind of really a question, it's a comment along the lines.
Yes.
You were talking about representation of the indigent without costing anything. I'm told that yesterday there was an article in the New York Times that the New York State Legislature has adopted a rule that bar applicants, as a condition of admission to the bar in New York State, must provide evidence or a certification that they have provided a certain number of hours of pro bono assistance.
I meant to mention that, and the chief of their senior court in New York has been tremendous in this. He's been vocal, he's been at times cajoling, and the rule, as I understand it, is you want to be a lawyer in New York, that's good. But take the bar exam, I suppose, and show us that you've already done 50 hours of pro bono of some kind. You've assisted in all the shows. Otherwise, you don't get to be a lawyer. So somebody will figure out an argument against that, but I can't at the moment. I think it's great. Okay? All right. Thank you very much. Bruce Jacobs. Where's he teaching?
The reason
Yeah.
you mentioned
Oh yeah. Oh yeah. Yeah, you know, it's interesting. It wasn't
What brings you to these parts?
Oh, yes, you look so familiar.
Very good. I thought I recognized you over here when I was doing ex-parties. Yeah, how's life treating you? Good. You look happy. We need you back. This hasn't been the same without you and Cindy and Robin Benetti. Yeah, so many people. Well, you've got my phone number, so if you ever need a call. Yes. Nice seeing you again.
I will. Yes. Yes, you are. Yes.
I asked the question
You know what comment that was made? I was talking to two staff people. Yes.
But my main practice is what I found is helping make this shape but I would also whether other ways to
I think that's the way to go. It's cheap. Yeah.
But the problem is, it is very difficult.
Well, they are. They were at the demonstration.
Of course.
In fact, that union is one, and I haven't figured this out, that union is opposed to race, and yet their members. So they spoke. Yeah. I can't figure it out.
But it's a good way to find common ground.
Yep.
And that's a powerful union.
Yep.
So if you get labor on board because it affects their constituents.